What's up, everybody? And welcome in to a little review of a very short hearing in the Sarah Boone case where we are wondering, will this case ever go to trial? And for a short hearing where we knew exactly what the outcome was going to be, there are a lot of interesting tidbits that give us some insight into how this trial is going, how this case is going, and if this next trial date that they're setting, which was sooner than I expected and predicted, is going to be a real trial date, or is it just going to be another hearing where we're going to get another continuance and we can almost guarantee it is not going to be the actual trial date in this case? We get some interesting indications of that. Also, some indications about how Miss Boone and her seventh lawyer may be working together coming from comments made in this hearing. So sit back, relax, enjoy this very short hearing we're going to break down and discuss together. Make sure you hit that like button and don't forget to subscribe. Hit that subscribe button to make sure you don't miss any future videos. Let's get to it. On the right side of the screen, you can see that is the assistant state attorney, and you're going to hear the judge's voice.
State of Florida versus Sarah Boone, 2020 CF 2603. State.
Dave Cacciatore on behalf of the state.
Okay. Mr. Cacciatore, good morning. The court was just made aware that a motion to continue waiver of presence was filed on January 12th, 2024 at 11:18 a.m. A copy of it was not favored to my office. My judicial assistant found it this morning by scouring the record once we did a call in the halls for counsel for Ms. Boone. The motion reflects that additional time is needed in order to prepare this case for trial. Counsel is still reviewing extensive discovery in this case and is also seeking appointment of experts with the S in parentheses. This court has approved costs.
So what's interesting is the judge didn't even really know about this motion until the hearing, where not only did the attorney waive his appearance, but Sarah Boone waived her appearance. It's not going to show up for this hearing. They all knew it was going to get continued. We all knew it was going to happen. We don't have to waste anybody's time. The state agreed to it. The state looks like they're sitting at home or in their office. This is a NBD, no big deal hearing. Everybody knows it's going to get continued. So I think this is a new judge. I can't see him. Judge Wooten was the old judge on it. It kind of sounds like Judge Wooten, so it could be Judge Wooten or it could be a new judge. I heard there was going to be a new judge on this case, but either way, they're asking for a continuance. The judge is absolutely going to continue it. But we're about to hear some comments from the judge that can give us some insight into how he is going to handle this case from here on out.
For a private investigator, the task to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. Reflects that speedy's been waived and that you had no objection to same. Is that accurate with regard to your objection or lack thereof?
That is, and I've had the chance to review that motion, Your Honor.
I'm sorry, Mr. Cacciatore, say again, sir?
That is accurate, and I have reviewed defense's motion to continue.
Okay. The motion does not identify the amount of time that they're seeking a continuance. In your conversation with Counsel Hobson, are you in a position to advise the court as to how long of a continuance they're seeking? Oh, no, the wherefore clause says 3 dockets. I apologize. Any objection to that, sir?
No, Your Honor.
Okay. The motion to continue will be granted.
3 dockets usually means about 3 months, give or take. So basically they're asking for about a 3-month continuance.
This matter will be continued for 3 dockets. Now, my understanding is that this is typically specially set. So do we want to have this especially set at a certain time, Mr. Cacciatore?
I think that would probably be better. Typically, Ms. Boone is elected to attend many of these hearings and not waive her appearance.
So specially set means it's locked in. We all know when it's going to be. We're not going to continue it. We're not going to finagle it around. Ms. Boone wants to show up, which is also very interesting that she didn't care to show up to this one. And I will say the fact that she waived her appearance not to show up to this one makes me think this is a better relationship with her 7th lawyer. And any indication we can get that things are going well. She's not checking up on him. She's not making sure he's working. She's not writing letters to the court. All of those are good things in the very early part of their relationship as attorney-client. He's filing these motions. He's asking the right questions. He's reviewing the discovery. He's asking for a short continuance because he wants to get ready for this trial now. Maybe she thinks somebody is finally taking this case seriously enough.
At them. So I also think too that we're at the point that that we're close to being I think ready for trial, and that I guess without getting into too.
He's going to say without getting into too many discussions or without Mr. Hobson here, but they are close to being ready for trial. Just surprising to me after reading Hobson's motion. Maybe he just means the state, but it seems like he's talking about his discussions with Attorney Hobson, that they feel like they're pretty close to getting to trial.
Too much more without Mr. Hobson here. Yes, I think just we could set it for a special set status.
All right, the court has availability for a special set on May the 3rd at 9 a.m.
So 3 dockets, just to further clarify, about 3 months doesn't mean exactly 3 months. It doesn't mean they're going to set it on April 17th, July, January, February, March, April 17th. So they set it to May 3rd, which is basically the closest spot the court has to special set something. We know once they set a pretrial, there's a trial docket in that month. May 3rd is the pretrial, 9 a.m. Sarah Boone's going to want to be there. They're going to show up. The court's going to want to know, are we ready to go? What is the status? That's the point of the status conference and pretrial hearing. Are we ready to go? Do we need to handle any motions in limine? Is there outstanding discovery? Is there any reason we need to continue this case because we want this case to go? So a May 3rd status conference / pretrial hearing is going to have a later date for the trial date, which we'll hear about, but it's also in May.
The court's inclined to have this as a special or as a final continuance due to the age of the case in the motion.
So that's important. The court intends for this to be the final continuance because of the age of the case. That's probably music to Sarah Boone's ear. She wants this case to go to trial, but only if her lawyer is ready. And even though the court says this is the last continuance, if the new defense lawyer has been on the case less than a year, says, I need more time, my guess is the court would still grant the continuance, but he's doing everything he can at this point to push this case to go to trial in May.
Not specifying anything more than a 3 docket continuance.
That's acceptable.
Okay. All right. We'll set this matter for a special pretrial on May the 3rd at 9 a.m. Ms. Boone we'll have a mandatory appearance for Ms. Boone at the
mandatory appearance. So the court is saying she has to show up now that she's waived her appearance at this one. Usually she wants to be there, but now she needs to be there. She has to be there. May 3rd.
May 3rd at 9 a.m. pretrial. What's the following trial period for that?
The trial period for May the 3rd would be May 13th.
With a trial period of May the 3rd.
So the actual trial date would start May 13th. So pretrial / status conference on May 3rd. Trial date would be May 13th, which is almost exactly 4 months from now.
13th.
Thank you, Your Honor. Thank you, Your Honor.
All right. Thank you, sir.
All right. So that's it. And so what we have now is a new trial date of May 13th. So do we think that's a real trial date, or do we think that's something that's just going to be another continuance? I think if Mr. Hobson cannot get prepared to be fully competent and able to represent Sarah Boone in a trial on May 13th, that it will get continued. But I actually think I'm going to put the chances of this going to trial on May 13th at better than 50%. Things can always come up. There can always be continuances. Something can happen to the court, the state, Sarah Boone, the lawyer, whatever. And with this case, all the problems, continuances, problems with lawyers, problems with discovery, problems with Sarah Boone, there's always going to be a chance it gets continued for some reason. But all of the indications point to May 13th. Let's review them. Defense counsel asks for specifically 3 months, a 3 docket continuance. The court grants it and gives it an extra month, 4 months. The court says this is the final continuance. And the state says we are close. We are ready to go to trial. And we think this should be special set, meaning it will take precedent over whatever other trial may be coming up, any other pretrial. This is the case that's going to be first. Special set. This is going on that date. the court will be less likely to set other trials on that date. And if they do, they will usually tell those other trials, you're going to be second in line, third in line, fourth in line, whatever. But we have a trial that is special set on May 3rd. They will tell the other cases in their courtroom on this court's docket that from now on, that they have a special set old criminal case that is likely to go to trial. So all indications are pointing that this May 13th trial date has a better than 50% chance of really being the day this case goes to trial. And you may not say better than 50% is that high of a chance, but it is astronomically higher than any other trial date that we've ever had set in this case. And the last video we reviewed, 12, 13, 14 times, umpteen times that this case has been continued. And also, no letters to the judge, no complaints that we know about. She didn't have to show up and make sure her lawyer was working on the case. All indications are pointing that Sarah Boone and her seventh lawyer, Attorney Hobson, are working well together thus far. It also seems like the court's going to do everything they can to push to figure out if they can get this additional funding for costs for an expert and get this stuff done quick. To me, it seems like a lot of stuff. That's why I thought it was going to happen end of 24, early 25, is because there's a lot of stuff to get through here. Are they even going to be allowed to hire the expert? And once they do, the expert's got to do their reviews, do their interviews, look at the evidence, be deposed, be questioned by the other side. The other side's going to have responsive experts. So that's why, there is still a chance this case gets continued in May, but I'm optimistic and hopefully you are too. Let me know what you think in the comment section. And again, don't forget to hit the like button on your way out. Appreciate you joining me as always. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.